Good morning, Suzanne. Can you hear me?
Yes,
I want to pause the recording. If I can. Oh, say, who's the host? Are you the host?
I don't think so. I have no idea what that means.
Okay. I'm going to have to go out and come in. Okay, I can claim host. I'm going to claim the host. Oh, I don't have that. I'm going to have to go out and come back in a different way.
Okay.
Good morning.
Morning.
Hi, Gary. Gary, I figured out how to share the screen and I'm ready to do it.
Good. Wonderful. So I have to leave early. So Dennis is going to be made the co-host and he will be having your back the second half.
Okay.
We'll never leave you high and dry.
Well, we hope not. What about the closed captioning facility?
Oh,
Because some
we're
people
trying-
like that.
Yes, we're trying to figure that out
Okay.
and we haven't yet. And I have Jackie working on it. If possible, what we'd like to do is just have it enabled for every conference.
Yeah.
Or every Zoom meeting, but she hasn't gotten back to me. So at the moment, I'm going to play around with it here in a minute, but usually Bobby asks me, and when she puts in the request, it's a simple yes or no to me. So if nothing else, I'll wait for her to ask and say yes.
Okay. Are you on here? Ken, are you on here? 32, so I think. Dennis, are we a go?
Yes. Let's
All
go.
right. Well, good morning, everyone, and welcome on this beautiful first day of fall. I have a rabbit outside my door here, my patio door, who's chewing away on the grass. So apparently the storm has done some good for somebody. Couple of housekeeping matters. This is week 2 of peeking behind the veil. Last week, I handed out an outline online and suggested that you keep that throughout the several weeks of the course. We will use it again today. I have some slides that you should have received this morning, and I will share the screen with this morning, and you'll see the slides live as well as having them in advance. we may use them again next week, so hang on to them. Third housekeeping matter, I mentioned last time that there is a movie called Worth, W-O-R-T-H, that is showing on Netflix. The theme of which, or at least a theme of it, is what is the value of a life? And it has to do with the lives that were lost in 9/11. But it tells you something about how we might go about assessing damages in a lawsuit. It's, I think, difficult to watch, but very moving. If you want to watch it between now and the last week, we will talk about it the last week. If you don't want to watch it or you can't watch it, no problem. Let me tell you what we're going to do today. There's a couple of questions from last week that I want to answer. We're going to do a quick review of what we did last week. Then we're going to put in evidence in our trial, and we're going to have closing argument. We're going to talk about what would happen on appeal. That's going to lead me to a discussion of a little bit of how courts are structured. And one of the reasons I want to do this is as we sit here in September of 2021, we will have a primary election in June of 2022, at which time you will be electing a justice to the appellate court. So I'm going to tell you a little bit about how that operates and who those people are, so that when you're faced with the question of voting, you have a little bit more background. We're also going to talk about damages in this case, but damages in general, how they're calculated, and some of the implications of how that operates. And at the very end, hopefully I will have time, I want to go back and answer a question from last time as to what is mediation, and I want to spend a little time on that. So that's the plan for the day. I will take a break about 10:20. I'm going to be asking you some questions, and I've played around a little bit this morning with the reactions button. And if you click on the reactions button right now, you'll see a green check mark. That means yes. And you'll see a red X button. That means no. So a few times this morning, I'm going to ask you to weigh in yes or no, and you can use the green check mark for yes or the red X for no. One question that came up last time that I will answer right now is, someone asked, is the Jackson County Courthouse open or are they holding trials? And I happened to run into a judge over the weekend, and the answer is yes for Jackson County. They've had 4 jury trials since spring. 3 of those were civil cases, and 1 of which was a criminal case. So they are open and in business. They have reconfigured some of the courtrooms and bought some of those plastic dividers and better mics so that people can hear through mask and through those glass dividers. But they are open and in business. I believe Williamson County is as well, and I can't tell you about the others in our area. All right, let's do a brief review. So last time we had this car accident at 13 and Glenview in Carbondale. That's the Turley Park intersection. And lo and behold, you the plaintiff, you the person who got injured, you were hurt because the other guy, we're referring to the defendant as the other guy ran a red light and entered the intersection when you were there and collided with you and caused you some harm. We decided last time that that was a tort, T-O-R-T. And a tort, we said, was a civil wrong, something that's been done to you that is harmful to you, but may or may not have any criminal aspects to it. And we said that that comes from the common law, and I'm going to talk more about that next week. My purpose in going through all these pretrial matters that we went through last time is partly reflected in the theme of the course, peeking behind the veil, because there's so much that goes on that you don't see as a person involved in the lawsuit. And you can easily question, why is it taking so long? What are the attorneys doing? What's going on? Why does it cost so much money? And I think it's good to have some sense of what it goes on that you might not see. So we decided last time, excuse me, you decided last time that you were going to get an attorney. to handle this tort, this personal injury, this car accident. And we discussed the statute of limitations being a 2-year statute of limitations in Illinois for this kind of case. And we are within that. We decided that we would have a jury for this case. We decided that the proper place to file this case was Jackson County. And I told you that venue is good where the plaintiff is you, where the defendant is, the defendant's the other guy, or where the accident occurred. So you live in Jackson County and the accident occurred in Jackson County, so we're good for on venue. We drafted the complaint and talked about how you would do some research on the law to know what it is that you need to say in the complaint. And we looked at a complaint last time, and I gave you a copy of a very simple complaint. I just thought you might find it interesting to actually see one. I want to make a note here that I think I missed last time. Sometimes people react to something they read in the paper and they say, gosh, is that really a lawsuit? Can anybody just file anything? And the answer is yes. There's no pre-approval. It's not like the judge reads the complaint before it's filed and says, yes, this is okay, you can go ahead. There's no pre-approval. If you can put together something that you can file electronically now and pay the fee or get the fee waived, then by golly, yes, you can file anything. Whether it survives judicial review, whether you win, those are other questions, but yes, you can file anything. But we have a good case. We talked last time that when the attorney signs that complaint, the attorney is representing to the court that the attorney has made a reasonable effort to be sure of the facts. Not that he can prove the facts necessarily at this point, but he's made a reasonable effort to know that the facts are true and that the lawsuit is one that the law recognizes. Peggy, I'm going to come back to your question in a minute. So we filed that complaint electronically and we did some discovery being the parties exchange information about the lawsuit and the witnesses and the injuries. And I pointed out that one of the reasons for that is that we want to encourage people to settle cases if at all possible. And one way to encourage people to settle cases is to eliminate surprises. Everybody puts their best case forward in exchange of discovery, and then they can make an assessment as to the value of the case and try to settle it. We talked about the various motions that might get filed along the way, and we finally got to the point of being at trial. Now, Peggy has asked a question about what if the driver was drunk? The other guy was drunk. Would that make it criminal instead of tort? It would make it both. So it's still a tort. So when I say it has no criminal aspects, I don't mean that. I'm sorry, what I said was regardless of criminal aspects, and that's how I should have phrased it, because there might be criminal aspects, there might not be. A harm was done to you and it's in your hands. We mentioned briefly last time that the purpose of the criminal justice system is to deter more bad conduct. And that's true of the tort system. We want to deter more bad conduct. There's a reason Ford no longer makes Pintos with the gas tank in the back that explodes in a rear end collision. It's because they've been deterred from doing so by those lawsuits. But I also said that the purpose of the criminal justice system in the end is law and order. The penalties, if there's financial penalties in a criminal case, they go to the state. Whereas the purpose of the tort system, besides deterring, the other purpose is to recompense people who have been injured, help them recover their loss. And so the financial consequences of a tort lawsuit goes to the person who's been injured to compensate for what was lost. All right, so we are at trial. Last time a question came up. I was talking about the fact that the judge begins jury selection by asking some questions of the jurors, and then the lawyers ask questions. And if there is somebody that has to be dismissed for cause, that's taken care of it early on. Cause meaning they know the parties, they're related in some way, They know the subject of the lawsuit. They simply could not be fair. Or they say they don't believe in this sort of thing, and they're just not going to follow the judge's instructions. Then I said that each side has peremptory challenges. Each side is allowed to strike jurors for any reason at all. You just don't think you want that person. There's something about it, that person, that makes you nervous. You don't think you're going to sleep well at night if that person's on the jury. Peremptory challenges, any reason at all. And someone asked me how many, and I blanked with the answer, but I've looked it up and made sure the answer is 5 per side, 5 per side. Now, if there were 2 or 3 defendants, then that number would be increased. All of this that I've just talked about would probably take 12 to 18 months, maybe 18 to 24 months before it would get to trial. And I asked the judge over the weekend, how long are most cases in Jackson County taking a case of this sort to get to trial? And she assured me probably 18 months. The one thing that might be holding it up is doctors' depositions, and I will talk about that later, particularly if somebody reminds me to come back and talk about that. All right, the jury is seated, and we are putting on evidence. And if you look at page 7 of the outline that I gave you on day 1, there are 8 questions. There are 8 bits of evidence that we have to decide whether or not we're going to admit. So we're going to take them one at a time, and you're going to vote. You're going to get to be the judge for the next few minutes, and you're going to say yay or nay. So again, that reactions button, the green check mark means yes, admit it. The red button with the X means no, keep it out. So how about the police report? We all know what happens, right? There's a car accident, call the police, they come out, the officer talks to the parties that are there, unless somebody's been transported to the hospital, talk to the parties that are there. They might talk to some witnesses, probably take some photographs, probably draw a diagram of the intersection, and try to get everybody's input as to what has happened. Pretty good, right? The police officer is a neutral. You're pretty sure it's going to be unbiased. They're trained for this sort of thing. So what do you think? Should we admit the police report into evidence? Yes or no? And I'm seeing you coming, you're weighing in here. Good job, folks. You found that reactions button, and I'm seeing a lot of yeses. This is very interesting. I'm waiting for a few others. Susan, is that a hands up? Are you asking a question?
I hit mine twice and
Okay.
nothing happened.
Well, all right.
Which
So,
Susan? Is there only one Susan today?
there's 2 Susans, but Susan McFall, what do you think? Would you admit
Oh,
this?
yes. But for
You
some
would.
reason, my reaction button did not.
Yeah, we both went.
We both went yes.
That's all right. You get to vote twice. Okay. All right. Well, this is very interesting. Everyone that I can see that has voted has said yes, with 2 exceptions. R.J. Robertson. Oh, Susan Metcalf, do you have a question? Susan Metcalf, do you have a question? All right. Almost everybody's voted yes, except R.J. Robertson. And for those of you who don't know, R.J. Robertson is a law professor, also retired. And he is helping me periodically by interrupting me and telling me I need to explain something. He voted no, and we're not going to count his vote because he might have some inside information here. And Steve Kraft voted no. And Susan Metcalf, I think you're voting no. Well, the answer is no. We're not going to admit this. Isn't that interesting? And here's why not. The police officer doesn't know anything except what people have told him. It's all hearsay. It's all information gained after the fact. Now, keep in mind what we want to see happen at a trial. We want people who have knowledge to come in, swear to tell the truth, take the stand, and say what they have to say, and then be cross-examined. So someone comes in and says, well, I was 3 cars back. I saw the accident. Here's what happened. And we say, 3 cars back, huh? Well, one of those cars in front of you, was that a truck, a pickup truck, or a big SUV, or something that would have blocked your view? So we get a chance to cross-examine the witness. Somebody says, well, I heard screeching and tires squealing. Did you have the radio on in the car? Did you have music playing in the car? How well did you hear? So we get to cross-examine them. Well, the police officer wrote everything down, but it's hard to cross-examine the police officer on what people said, because the police officer is simply telling us what he or she heard from the witnesses. Don't we want those people to come in instead? So that's reason number one why we do not admit the police officer's report. It's hearsay. We want the people. The second reason we are not going to admit it is because there's a statute in Illinois that specifically says police reports do not come into evidence in a case like this. That's not to say all cases, but a case like this, police officer reports do not come in. The Illinois General Assembly has made that decision. So very interesting. You can remove your votes if you can figure out how to do that, or just give yourself a moment, because I'll have another question. But the police report is not coming in. Well, what about statements made to the insurance adjuster? Because again, we know how this works, right? There's an accident, you call your insurance company, the other guy calls his or her insurance company, and the adjuster gets on the phone and says, can I talk with you about the accident? And by the way, this is being tape recorded. Tell me what happened. And you do. And the adjuster drafts that up, types it up, I assume electronically today, and has a report. That would seem to me to be pretty good, because it takes place within days of the accident. We just said that probably this trial is taking place 18 months, 24 months after the accident, but that insurance adjuster's report was made probably within days. So again, would you vote? Yes, it comes in, green. No, it stays out, red. I see somebody shaking her head, no. I see some yeses. I see some no's. I'm seeing more no's this time. Trying to pause here for a few seconds to let people weigh in and find the right buttons. I don't like dead air, so I tend to keep speaking, but I ought to wait patiently while you vote. Ken and Carolyn apparently have the cat on their lap, and they can't get to the buttons to vote, so they're not even voting here on this one. Well, we're pretty divided this time. No, it's not going to come in, because again, it's all hearsay. It's all hearsay. Bring the people in whom the adjuster talked to and let them take the stand and testify, and not secondhand from the insurance adjuster. So nope, I'm ruling that out. Well, what about photos of the scene? Photos of the scene. So somebody took photos right after the accident. We could see the damage to the vehicles. Let's vote on that. Green for yes, it comes in, red for no. So would you admit the photos? Okay. Most people are saying yes. Yes, I think we would. But remember, no exhibit comes into evidence without a witness. We have to have somebody. So some person is going to have to take the stand and say, I was 3 cars behind. I really didn't see how the accident happened, but I pulled over, got out of my car, and took pictures of the both vehicles immediately after they stopped and people had basically the collision was over. They're going to have to be able to testify that the photos they took were accurate depictions of the scene as it existed at the time. We call that laying a foundation. They're going to have to be able to say, I was there, I took these photos, and it's a true and accurate depiction. One of the values of attorneys exchanging this sort of information early on in the case through discovery is you can find out there's something about this photo that just doesn't look right. I think maybe it's been photoshopped. And you have time to check into that sort of thing, because as we all know today, you could take my head and put it on the body of whatever Hollywood starlet there is and make me look like I'm that person when I'm not. So the photos would come in, I think, but somebody's going to have to testify that they're true and accurate. And the value of having them exchanged in advance is people can have time to look into whether or not there's been some tampering. All right. How about an estimate from the body shop? Again, we know how this works, right? Accident, car has been damaged, you get it towed to the body shop, you ask the body shop for an estimate, and you send that in to your insurance company. And the insurance company relies on that estimate early on in the case. So what do you think? Should the estimate come in? Green for yes, red for no. Okay, well, Professor Robertson, I'm afraid you're going to flunk on this one. That's probably the first time in my life I've been able to say that to RJ. No, that doesn't come in. And here's the reality that's going to surprise you. I know in the real world, insurance companies rely on the estimates from the auto body shop. But again, it's hearsay. That piece of paper is saying that there was damages in the amount of $8,000. And here's the kinds of things that have to be replaced, and the total's up to $8,000. Well, then let's have that auto mechanic person come in and take the stand and say, I saw the vehicle, here are the damages, here's what I'm going to have to do to fix it, here's how much it's going to cost. Then we can cross-examine that person and say, okay, now, Mr. Auto Mechanic, body shop expert, so the accident happened on this part of the car, but I noticed that you've included here repairs to the trunk that wasn't damaged in the collision at all. So is it possible that there were damages to the trunk way back when that you're now including? So we can't do that. We can't cross-examine that expert if he's not at the courthouse. So we're going to throw out that estimate. And I know that's going to surprise many of you, but that in fact is the law. Well, how about the receipt? What if you actually paid that body shop to do that work, and now you're introducing the actual receipt? Do you think that should come in? So again, green for yes, red for no. How about the paid receipt? Would that come in? More yeses this time, a couple no's. Yes, it comes in. And here's one of those weird things about the legal system that might surprise you, but the law says, we assume you only pay bills that are reasonable. We assume that when you paid this bill, you made the assessment that the damage, that bill from the auto mechanic, the body shop mechanic, was fair, was reasonable, was customary, or you wouldn't have paid it. So if you paid it, you've made that assumption. We're going to let that in. So I know it's weird, but that in fact is the law. All right, moving on. How about a witness? How about somebody who was standing there at Turley Park trying to cross the street, waiting for the traffic to clear for that 5 seconds that you had to cross this intersection there, and that witness is going to come in and tell about what happened? Is that going to come in? Red, no. Green, yes. Yeah, that's the best evidence we have, right? Somebody who was actually there on the scene, is neutral, independent, not on anybody's side. That person can come in and testify, and we can cross-examine that person. We can say, well, isn't it true that the plaintiff here, the person who was injured, is your brother-in-law? Maybe you're biased. Or we can ask, I noticed that you were carrying a bag with the bottle. How much were you drinking before that accident happened? And were you actually sober and able to, so we can cross-examine people. Some years ago, I was conducting discovery on a car accident in Alton, Illinois. And a witness was a Methodist minister. Methodists are not supposed to drink. But a fair question anytime with witnesses, had you had any medicine or had you failed to take any medicine that you should take? Had you had anything to drink, any drugs that might have altered your perception? So I say to him, had you had anything to drink that day? And he says, I'm a Methodist minister. I said, yes, sir, I know you're a Methodist minister, but I'm asking the question, did you have anything to drink? Luckily, both of us were smiling through this. We understood that I had to ask and he had to answer, and no, he hadn't. But it's a fair question. But yeah, the witness is going to come in, and if you think the witness is biased or if you think the witness is impaired in some way, you can ask questions. RJ, I'm going to ask you, because I've got 2 more pieces of evidence. When we finish that, I want you to remind me, please, to talk about swearing in a witness once. All right, how about these 2 questions? So the other guy, the guy that hit you, was ticketed for running a red light. So at some point there was a trial in traffic court on that ticket. And let's assume that he or she, I said last time, we know it's a he because women would never be so stupid as to run red lights. We know that, right? Everybody we see running a red light at the intersection is a man. So let's keep with the man for a moment. So he showed up at traffic court and he pled guilty. Would you let his admission, his statement in traffic court that he pled guilty, would you bring that into evidence here? Do you think that's fair to use to show that he breached his duty of care? Yes or no? Green is yes, red is no. We're a little divided, more yeses than nos. I think we can bring it in. I think it's an admission. But let me bring up an argument that I think is a good argument. I think it would lose, but I think it's a good argument. I'm not going to ask for any show of hands here, but how many of you accidentally sped once in your life in some distant county and a police officer stopped you and gave you a ticket? And you got home and said, there's no way I'm driving back to Champaign County to appear in traffic court to argue with the police officer. I'm just going to write a check and send it in. What the heck? I think there's an argument that with traffic fines like this, it's sort of the cost of living in modern society, and we just pay it, and we don't really mean to be making an admission. I think it is an admission. I think it would probably come in, but I think there's an argument that I could make that the judge should not admit it. I think I'm going to lose, but I think probably all of us have had the experience, or we know someone who has been ticketed out of town and just paid the thing rather than deal with it. Well, what about if he pled not guilty and there was a trial in traffic court, and then he was convicted in traffic court of running the red light? Would that conviction come in here? So green, yes, red, no. Ken and Carolyn, don't think I haven't noticed that you're not voting at all. And I think you're using that cat on your lap as an excuse to duck these important questions here. So most of you are saying yes, a few no's. I think it would come in. But with both of these last 2, the judge, I think, is going to have to give the jury what we call a limiting instruction. I think because how many times a day, a week, do you not see people running red lights and there are no accidents? So just because he ran a red light does not mean he's liable for hitting you. You're going to have to show he ran a red light, yes, and the admission at trial court or the conviction at trial court on a traffic court is very helpful for that purpose. But now we have to link it up to the accident. Because he ran the red light, he entered the intersection when you were in that intersection in a proper manner, and he collided with you. It's a tiny little extra step, but you got to make that link. He ran the red light, yes, but because he ran the red light, he collided with you and caused you harm. Okay, so those are most of our evidence that we're going to introduce. I want to go back in time and tell you a story. Most of the time, thanks, RJ. Yes, and RJ has anticipated my next question. Thank you, RJ. You're really helpful. I'm going to owe RJ when this is over. So most of the time we bring somebody in, we ask them to take swear to tell the truth and be seated and state their name, and we proceed. Well, I once had to bring to court, actually it was a hearing, an administrative hearing, but same kind of process, a person who was an adult who's developmentally disabled. The state of Illinois wanted to fire a state employee who worked at a state facility where there were adult developmentally disabled people. The charge against this worker was that he had abused some of the adult disabled persons. When I say abused, I'm not talking about terrible sex abuse. It was more of a mocking kind of thing, but it was improper. Well, who's going to be the witness? Because I will tell you that none of the union employees on the scene that day are going to remember that they saw anything. So who are my witnesses? They're the adults who are developmentally disabled, who by definition have limited memory and limited ability to perceive and recall. The state gave me three residents that they thought were witnesses. I interviewed all three. I decided only one was probably going to be capable of testifying. So I prepared her for trial. And I asked her, what does it mean to tell the truth? Because most of the time when you come in and we call you to trial and Kathy Fatz is called as a witness and we ask her to take the stand and we don't question when she swears to tell the truth, does she know what that means? But when you're dealing with a developmentally disabled person, that was a fair question. So before this woman was sworn, I had to say to her, what does it mean to tell the truth? What does it mean to lie? What happens if you lie? And she explained that the devil would get you if you lied and that God wanted you to tell the truth. And that was good enough. And the hearing officers swore her in and she testified. I will tell you that the rest of the case did not go as well as that moment right there. She was able to tell us what happened, but then when cross-examined, anything that the cross-examiner asked, so the weather was really nice that day, right? Oh yeah. The fact was there'd been a terrible snowstorm and people were working overtime, and that's probably what led to the abuse. So that case did not go well, but it was an interesting experience to have to actually prepare a witness to explain what it means to tell the truth and have to convince the judge or the hearing officer that this person is capable of telling the truth. Now, RJ reminded me that we need some medical testimony. Doctors do not like to come to trial. Doctors really do not want to spend their time in the courtroom. They particularly don't want to spend their time in the courtroom if they have to sit and wait until it's their turn. So typically what happens is the attorneys take the deposition of the doctor in advance. Today, those are videotaped and they're shown as though you're watching television. So in this case, there would have been a deposition taken of the treating doctor. Probably what would have happened here is You were injured at the scene. You were taken to the emergency room. There was a treating doctor there who then referred you to your own treating doctor, your own family doctor for further follow-up. And we would probably just take the deposition of your family doctor. And here's why. Your family doctor is going to have the report from the emergency room, going to have access to the x-rays, going to know what treatment the treating doctor recommended, as well as what treatment was recommended at the emergency room. And he can talk about all of that because he will have relied upon all of that in making his diagnosis and his recommendations for treatment. So that would have been done in advance. Now, someone asked me, what if the auto mechanic that we bring to trial, because remember I told you that that estimate wasn't going to be good enough. Maybe you wanted to bring the guy from the auto body shop in to testify. And somebody said, well, what if he's your brother-in-law? That's exactly why we want to be able to cross-examine people. We want to be able to cross-examine people so we can say, how long have you known this person? How often do you see this person? By the way, how often do you have dinner in her home? How often do you go back to your home at night after you've had dinner? We've sort of created a little romantic relationship there, and maybe the auto body guy is shading the truth a bit to favor his girlfriend. So yeah, we can cross-examine. That's the reason we have cross-examination, to test the strength of someone's testimony. Who is at fault if the person going through the red light is hit by the other person? Good question, and I'm going to defer that until I have more time to think about that one. All right, so we put on all this evidence, and you did a pretty good job overall this morning of deciding what to admit and what to exclude. And now we're going to prepare for closing argument. And as part of preparing for closing argument, the judge is going to have decided on the jury instructions. And the reason the judge has to have decided on jury instructions before closing is that in the process of making closing argument, the attorneys want to be able to know what the jury instructions are going to be. So how do these jury instructions get done? Well, if you've got it handy, look at page 11 of that original handout. And page 11 shows you two jury instructions. Jury instruction 2101, the meaning of the burden of proof, and jury instruction 2102, what a burden of proof would be in a case like this. Now, you'll notice that 2101 has two indented paragraphs, which you don't see on 2102. There's a reason for that. Those two indented paragraphs, so under 2101, you see it's the actual instruction that would be given to the jury reads, when I say that a party has the burden of proof on any proposition, or use the expression if you find or if you decide, I mean, you must be persuaded, considering all the evidence in the case, that the proposition on which he has the burden of proof is more probably true than not. We talked last time that the burden in a civil case is preponderance of the evidence. If we take all the evidence, sort of hold them in our hands, and they tilt ever so much toward the plaintiff, then the plaintiff wins, because the plaintiff has shown you the preponderance of the evidence ever so slightly favors the plaintiff. The plaintiff has shown you that it's more probably true than not that what happened is what happened. And if it's 50-50, the plaintiff loses, because the plaintiff had the burden of showing you that it's more probably true than not. Well, where did this thought come from? And those two indented paragraphs tell you where it came from. The instruction that the judge is going to read to you in the year 2021 came from a case in 1927, a case in 1929, 1909, 1953, and 1942. Pretty well established law in Illinois, would you say? And then there's the second paragraph is a little guidance to the judge. By the way, judge, reversible error if you fail to give this instruction. And that comes from a case in 1984. The jury would never see those two indented paragraphs. Those two indented paragraphs are in a book that we call Illinois Pattern Instructions. Next week or the week after, I'm going to tell you more about how those pattern instructions come to be, because something I want you to appreciate is the amount of time that lawyers and judges give as volunteers to doing things like drafting these pattern instructions. We'll talk about that later. But those two paragraphs are guidance to the judge and to the attorneys. They would not show up. That what the jury would see is 2101, that one paragraph, and then 2102. I don't want to dwell on this. I know it gets a little arcane, but I just wanted you to have a sense that the jury is given guidance, and the guidance comes from well-established law that's been prepared by attorneys and judges over the years in pattern instructions. Once in a while, you'll get a novel case where there are no pattern instructions, and then the attorneys and lawyers have to draft them. Something to be aware of. I know on television that at the end of the trial day, when the jury goes home, the attorneys go out and they eat and they drink and they party and they have friends over and they sleep with each other, and there's all kinds of stuff going on. In the real world, when the jury goes home, the attorneys go back into the judge's chambers and they work out stuff like this. They decide what are going to be the jury instructions. They review evidence that's going to come in tomorrow. And if there's going to be objections, they try to get them resolved. One of the things that I want to point out throughout this course is the role of the judge and the jury. Remember that for 18 months, 12 months, whatever it was, all that preparation, the only person in charge was the judge. Throughout the trial and ruling on evidence, it's the judge. Now that we get to the very end, the jury takes over. It is the judge's job to determine the law. It is the jury's job to determine facts. So the jury is not asked, is there a duty to keep a proper lookout when you drive? Is there a duty to be careful, to be a reasonably prudent person? That's the term we use in the law when you drive. No, that's the judge's job. That's a legal issue. Is there a duty? Did you violate that duty? That's up to the jury. When you violated that duty, did you cause harm? That's up to the jury. And that's what the attorneys would talk about in closing argument. Because I am at 10:15 and I want to take a break, I think I'm going to take it right now. I'm going to do a 5-minute break. And when we come back, I am going to do closing argument. So I'm going to step into the role of your attorney. And the other guy, by the way, is Ken Loving for the purpose of my closing argument here. I'm sorry, strike that. You have become Ken Loving. Ken Loving is the plaintiff in this case. Ken Loving's the person that got injured. And I'm going to be Ken's attorney, and I'm going to do what I think would be closing argument in this case. And you can judge how well. As I take this break, you're going to have a chance to send in any questions that I've not yet answered. And let me give some thought to those. But I'm going to take a 5-minute break, and we will reconvene at 10:22 by the computer clock. So let's take a quick break.
cholesterol in person, just checking to see if the email I got from you is legitimate or not. Give me a call at this number when you have a chance. 618-319-2036. Bye. Have to be at the cancer center at 1:20. Just letting you know my schedule. Is it ready? Oh.
All right, and welcome back. Someone has asked, well, a couple questions here. Someone has pointed out that she did not receive material this morning in an email. I'm going to be sharing that material with you on the screen here in just a few minutes. So you're going to see it. Beyond that, I will try to send it to you later if you did not get it. But for right now, you're going to see it on the screen. Someone's asked me, do I think jurors are capable of determining the facts? I think it varies. I think in a case like this, yes. I think in a very complicated technical case, no. I have listened to testimony that I can't begin to understand. I don't know how a jury would. I think that's a good reason not to take those kind of cases to trial if you can avoid it. And we'll talk about some of that in the last class. If a defendant's attorney is dragging the feet, not scheduling depositions, can this affect the outcome of the case? Well, yeah, insofar as the more you delay, the more maybe people become unavailable as witnesses. Yeah, it can affect it. Can the defendant or the plaintiff, for that matter, be penalized? Yes. If you have a good judge, yes. Good judges keep the attorneys moving. There are rules that require periodic pretrial conferences, and that point is exactly the reason why we're telling the judge, keep these attorneys under control. If you have a good judge who keeps the attorneys under control, this should not happen. Does it happen anyway? Yes. Are there sanctions? Yes. Are they always applied? No. That's why you should elect good judges. And I know that's easier said than done. Could we call the defendant, the other guy, the guy who ran the red light, could you who got injured call that person to the stand to testify? Yes. Can that person invoke the fifth? Yes. Because a speeding ticket is a criminal sort of thing. I know we don't think about it as a criminal sort of thing, but it is. And would you have the right, if called to the stand in a civil case and asked, did you run the red light? Could the other guy say, I refuse to answer on the grounds that it may incriminate me? Yes, he or she could do that. If, however, the trial were over, there's that protection would be meaningless because the trial's over in the traffic court. Jackie should have sent out an email this morning with the link for today, and that PowerPoint should have been there. But if it wasn't, I'm going to share it with you here. There's a couple other questions I'm going to defer because, by golly, I want to get this done. So I'm going to share my screen in just a second. So here's how closing argument might go. And I'm going to use Tom Loving as you. You're all Tom for this purpose. Tom's the person that got injured. So it might go like this. As soon as I get a cough drop. Good morning, ladies and gentlemen of the jury. Thank you very much for your time. Basically, there are two questions you have to deal with. The first question is, did other guy cause this accident? Did other guy run a red light, failed to keep a lookout of who was in the intersection, enter the intersection when it was unsafe to do so, and because of all that, collide with Ken and cause injury to Ken and to Ken's car? I think the evidence is very clear on that. You've heard the testimony, you've heard the admission by the other guy, you've seen the photos of the accident scene and the vehicles after the fact. I think that question will be very easy for you to answer in favor of Ken. So that leaves a second question, and that is, how will Ken be compensated? And in that regard, there are some things I want to discuss with you, and I'm going to use an easel that's right here next to me that you can watch as we go through this argument. So just to recall for you, immediately after the collision, Ken was taken by ambulance to the hospital. He was treated at the hospital by a doctor. While he was at the hospital, x-rays were taken. He was prescribed some medications at the emergency room for relief for the pain and for relaxing the muscles that were injured in this collision. He had those prescriptions filled. He was then sent to his family physician, referred to his family physician, and he did indeed follow up within just a week and saw his family physician, who also examined him. And you heard from the family physician. And the family physician told you that he reviewed the report from the ambulance and from the ER, and he reviewed the x-rays. And he came to the conclusion that the injuries that Ken has suffered are serious. Fortunately, there were no broken bones, but there were other type of injuries. We call them soft tissue injuries that are just as serious, that are very painful, and that are very disabling. And based upon reviewing all these records and the exam that the family physician conducted, he was able to say that these injuries were caused by the accident. Prior to the accident, Ken had never had these kinds of injuries, never complained of stiffness and soreness and limitations in his ability to use his neck, his arms, his shoulders, his back. Now he did. The family physician sent him to physical therapy for a period of 6 weeks to relax those muscles and get them working again. He prescribed more medications. He also told Ken to get some ice packs and heat packs from the local drugstore and use them at home to ease the pain. All of that I would have put in dollar figures. But because I didn't want to take the time to have to do all that, we're just going to pretend I put in dollar figures. Let me talk a little bit more about Ken's injuries. As I said, the doctor said that these were soft tissue injuries. As a result of this, Ken was very sore, very stiff, very limited in his movements. He told you that for the first 2 days after the accident, he could not take a deep breath. And the reason he could not take a deep breath is because during the accident, the seat belts held him into place. We're very fortunate for that. But because of that, they bruised his chest bones, and it was very painful to take a deep breath. So for 2 days, he could only take shallow breaths. He told you that it was very difficult to sleep for days after this collision because he could not get comfortable at night. He told you that even driving was a challenge because he was not able to turn adequately in the car seat to see what was coming from his left or his right because of stiffness. He told you that he loves golf and that he's been a big golf player, and that typically he would play twice a week, once a week with a group of friends who played with for years, and once a week in a group of seniors that play tournaments. He couldn't play golf for this period of time after the accident. He told you that he's very proud of the fact that he created a golf tournament that benefits children in Jackson County, and that normally he would be one of the main workers, and he would be out the day before setting up banners and signs, and the morning of and setting up tables and so on. And he was unable to do any of that this year. All he could do was go out and shake hands with players. He could not play. This was very disappointing to him. He told you that he also loves to garden, and that once a week he's very careful about mowing lawn and trimming and raking up areas that need to be raked up, and trimming around the house, trimming around the back deck and around the sidewalk, and sweeping up all the grass clippings. And he could not do that because it was so painful. He was so stiff, he was so sore, and he had to hire somebody to do that for him. And he told you that he's a big gardener. He took a lot of pride in keeping up the garden. So in addition to doing the lawn work, he did a lot of work with regard to flowers and bushes and trimming and weeding and pruning on a regular basis. And he could not do that this fall. And as a result, he's been very disappointed that his garden was just not as nice as it should have been. These were very, all of these disappointments are a result of the stiffness and soreness from the accident. So we're going to add to the list of damages, the damage to the car, which you've heard is $8,000, and the cost of the lawn service and yard maintenance that he had to hire in order to get this work done when he was unable to do it. All of this totals $35,000. Now, ladies and gentlemen, you're asked to look at two things with regard to trying to compensate Ken for his injuries. His economic injuries, and I've just told you those total $35,000, but also the pain and suffering that he has endured, the disappointments that he's endured because of his pain and suffering. I'm not going to give you a dollar figure. I'm going to ask you to do that. But I am going to ask you to consider the $35,000 that he has paid out because of these injuries, because of this collision. And I'm going to suggest that when you go back and you give this some serious consideration, that your deliberations should start at a figure of $100,000. We will let you conclude the best figure. We trust your judgment. And with that, I remind you, my client and I thank you very much for your time and your consideration. That's the end of my closing argument. Any thoughts about it? Now, somebody had asked me how long would it be? As a matter of fact, it would probably be an hour in a case like this. And yes, the judge does limit the time. What is pain and suffering? Pain and suffering is what the jury says it is. It's all those losses of things that you can't do because you're in pain. It is the pain and anguish of being sore, of hurting.
I think the one thing you didn't say was how long the pain and suffering was anticipated.
Actually, as I was making that sentence, I was thinking that same thing, Barbara. I would have done that in real life. Here, I'm making up facts as I go along, so
Sure.
failed to do that. Other thoughts? What about days off work? Yes, I was assuming that Ken is retired and that you, any of us, are probably retired. But as a matter of fact, we would have gotten off. We would have, if we were working, there would have been lost work days, and we can compensate you for your lost work. And if you had to take sick days or vacation days, you can be compensated for those as well. If I win, who pays your insurance company? We are going to get to that maybe today if I'm really lucky, but yes, we're going to get there. Do you consider how it would be paid? Yes, we're going to get there. Okay. All right. We're going to talk about more about insurance here in just a few minutes.
35,000 to 100,000 seems like a pretty big leap.
Well, let me disregard my plan for the day and answer this series of questions. Let me talk a little more about damages now. I was going to wait, but let's just do it now. So some of the things that you could get: economic, damaged property, medical expenses, we've talked about that, future medical costs. So there might be a case where the doctor says there's going to be more surgeries, there's going to be more treatment in the future. Sometimes attorneys will decide to hold a case, wait for a few months, maybe longer, to get a better sense of what the future is going to be. But you can ask the doctor to make projections about future medical treatment necessary and the cost. Lost wages, we talked about. Lost earning capacity. Suppose this were a younger person who was still working and the injury was such that that person will never work again in that field. You would have to hire an economic expert who would say, this is the salary at the time of the accident. This has been the progression of this person's salary. See how there's been regular raises. This is the likely progression for the rest of that person's life had he or she not been injured and stayed in that field. That would total X dollars. And then you have to take into account taxes and inflation and all kinds of stuff. So you have to hire an economic expert to do that. If it were a person who was the primary household person who got injured and you had to hire a cook or a maid or a cleaning person or like in this case, a lawn service, yes, you can recover all of that. Those are economic losses. Then there's the non-economic loss, pain and suffering. What is pain and suffering? It's just that. It hurts. I don't like this. I want to be able to sleep all night without waking up every 30 minutes when I turn over because I'm in pain. Disfigurement, mental anguish. You noticed how often I use the word disappointment. Loss of enjoyment of life. There's this argument. Some people think that there should be a particular category that says this person has lost enjoyment of life, whether it's forever or for 3 weeks or for 3 months or whatever it might have been. You notice how I kept using the word disappointment, couldn't do something he enjoyed. I was hinting at that without making this a particular category. If this were a more serious case, a spouse might be able to recover for loss of consortium. What's that? That's the loss, that's the inability to have the affection, companionship, help, and assistance of the spouse, and to have sexual relations with the spouse. If it were a wrongful death case where a person had died, the person's children might be able to recover for loss of guidance and moral support of the father or mother of the parent. So those are some of the non-economic damages that the law recognizes. Now, in this case, why would it be $100,000? Beth asked. Well, here's sort of how it works. So the first thing that's going to happen is the attorney is going to get his or her cut of that $100,000. So personal injury cases, attorneys take these cases on what we call contingency fee. I will get a fee contingent upon winning. If I don't win, I don't get anything. If I win, I get a share of the recovery, typically 30, 33, 40. Sometimes the attorney will say, if we settle before trial, it's 30. If I have to go to trial, it's 33 or 35 or 40. I suppose it could be higher than that. These are the usual. So of that 100,000, the attorney is going to take, let's say, make it easy on me, and let's just say $33,000. Then you have the cost of the case. So actual money that the lawyer paid out to get the medical records, to hire an expert witness if you needed one, the doctor's deposition in this case, that would come out of that $100,000. And then there are liens, L-I-E-N-S, liens. Liens are claims. So the hospital wants to get paid. The doctors want to get paid. And if your health insurance company paid for this in advance, it wants to recover what it paid because somebody else caused those injuries and it wants to recover. If you're on Medicare or Medicaid, the government wants to recover. So $35,000 was, let's deduct the $8,000 for the car insurance. Let's say that there was about $26,000 in this case in actual medical bills. Those have to get paid, or the person who fronted that money, the health insurance company, the Medicare, has to get reimbursed. So the attorney got $30,000 or 33. 28 or so went to medical and other liens. There were costs of the case. Your share is going to be down to about $35,000, $40,000. That's what you're going to get. Attorneys use a rule of three. If the medical expenses in a case is about $35,000, we sort of use a rule of three. About a third of it's going to the attorney, about a third of it's going to pay those medical bills. We got to pay those back. We got to pay back the people who fronted that money. And then a third is going to go to you, the plaintiff. If you're in a very conservative county where people don't like paying out money, 100,000 might be a tad high. If you're in a county like a very industrial county where there's a high degree of heavy industry and workers get injured a lot, and particularly if it's a union county, a county where there's a lot of union workers and they understand what it means to be injured, not to be able to provide for their family, that 100,000 is probably going to be low and you're going to raise it. It's a rule of thumb. There's no magic to it. There's no law here. It's experience. That's why, Beth, I went from 35 to 100,000. Because I know that of that 35,000, the way I was calculating it, 8,000 was for the car. That means 27,000 it was for medical expenses. 27,000 is going to go back to doctors. 8,000 is going to go back to my car insurance because they can recover. Third of it's going to my attorney. I'm going to get the difference. That's the reality of how this works. So when you read somebody got $500,000, they probably didn't get $500,000. They maybe got a third of 500,000, maybe. Depends upon how many other liens there were. A lien is a claim. If you remember, I said the first day that when your attorney entered the case, your attorney let the insurance company know, the other guy's insurance company know that there was an attorney. And I told you that one of the reasons for that was so that the other guy's insurance company would not talk to you, would know that you are represented by an attorney, and the insurance company can only talk to your attorney. The other reason the attorney is going to let the other guy's insurance company know that there's an attorney is because the attorney is announcing to everybody that there's an attorney lien. And if you start writing a check to settle this case, you have to write that check to me as well, because I'm entitled to a share of this recovery. When you have work done on your house, the workers can have liens against your property if you don't pay the bill. A lien is just a claim that says somebody else is entitled to some money. Now, let me see if I've totally confused you or if there's any questions. Shouldn't these expenses be explained to the jury? Well, that's a good question, and I'm going to pass on that because it's a good hour-long discussion. That I don't want to take up now. The argument against explaining it to the jury is that once the jury hears about insurance, they might be inclined to up the amount, a crazy amount, because they hate insurance company, or they might be inclined to lower it a lot because they don't want the insurance company getting anything. Would someone really sue for only $35,000? Yes. Do attorneys take cases of such low amount? Yes, because in this case, it's a fairly easy case to put together. A medical, if you came to an attorney and said, my doctor malpracticed and cost, the damages are $35,000, the attorney is going to say, it is not, we cannot put together a medical malpractice case to recover $35,000. But a car accident case like this, yes, every day. And again, the last week, I'm going to tell you a system that exists in some Illinois counties for cases like this, but that's week 5. Okay, those are damages. And that's how they recover, the breakout of the damages works in terms of recovery. As long as I'm talking insurance companies, let me talk about 2 other quick things that I don't want to dwell on, but I just want you to know about. So in Illinois, you are required to have insurance if you drive. And the minimum insurance that you can have in Illinois is $25,000 per person in an accident, or $50,000 if there's more than one person, or $20,000 in damages to the property, the car. That's Illinois. Now, let's say that we have a terrible car accident. Let's say the damages are easy $200,000, lots of medical bills. The actual out-of-pocket damages, I don't mean what you're asking a jury for. I mean the actual medical bills are approaching $200,000. But the person that hit you had low insurance, just $50,000 or $25,000 per injury. That's all the insurance company is going to pay. So if Joe, we're going to make Joe the other guy here. If Joe has minimal car insurance and he hits you, and damages are going to be an easy $200,000 just in medical expenses, probably approaching $750,000 in damages. All Joe's insurance company has to pay is this minimum, $25,000 or $50,000. Who pays the difference? It might be Joe. So if Joe hits you and Joe's insurance company pays his $25,000 or $50,000, and a jury came back and awarded, let's say, $700,000 in damages, Joe is liable for $650,000. Now, in all probability, if Joe is buying insurance at the minimum, Joe probably doesn't have a lot of money. So you would put a lien on his house, on his car, you would garnish his bank account, and the reality is you probably aren't going to get much at all. But you should know that your insurance company will only pay out the amount of money that you have chosen in your policy. And that is why I told you last time to look at your declaration page. I told you last time that when your insurance company sends you a bill, I still do the old paper and mail it to me in an envelope kind of bill. There is, the first page is the bill, send country companies this amount of money. The second page is the declaration page. And it might have a chart something like this. And it tells me, this, by the way, would never fly in Illinois because it's too cheap a policy, but it was the only one I could find online that was an easy one to copy and paste. So it's telling me that the body injury liability is 15,000, the property damage is 10, the uninsured motorist is 15,000, the underinsured motorist is 15,000. Take a look at your declaration page. It will have to be more than this because you're in Illinois. But I just want you to take a moment to do that and look at how much you have purchased from your insurance company, how much money your insurance company is willing to pay should you unfortunately have an accident. I have the maximum. I have the maximum for a good reason. I'm an attorney. When people find out that I'm an attorney, that headache turns into a brain injury. I'm exaggerating slightly, but people tend to find, if they think the other side, the person that accidentally hit them, because I would never, of course, run a red light and hit anybody, but if I accidentally hit somebody, they find out I'm an attorney, their injuries tend to get heightened. So I do the max, but you do what you want to do. I just want you to know that should you take out a low dollar policy like this, and should you have the misfortune of injuring someone with serious injuries, you personally could be liable for the difference. Don't want to scare you, just want you to know how this works. One other quick thing I just want to say about insurance, only so that you are aware of something that I think you should be aware of. There is something called subrogation, and I took this from the Allstate webpage that they published in July of 2020. And they tell you that subrogation is the assumption by a third party of your right. All they're saying is, in subrogation, the insurance company steps into your shoes and can sue. So even if you decide you don't want to sue, but you turn to your insurance company and you say, hey, I was injured, Allstate, State Farm, country companies, farmers, take care of this, compensate me for my car, compensate me for my injury, but I don't want to sue. The insurance company could sue on your behalf. So when somebody says to you, don't worry, I won't sue, they might not, but their insurance company might. Just want you to know that. Don't want to scare you, just want you to be aware of how these things work. If I have an umbrella policy, will it make a difference? Yes, it will, and that's why I have an umbrella policy. So an umbrella policy is this. I have insurance on my house. I have insurance on my car. They both have policy limits. Then I take out an umbrella policy. It is an umbrella. It adds, not only does it add to my car insurance and my house insurance, but it also adds things like, should I be sued for slander or libel? So yes, I do this. Why do I do it? Because I'm an attorney and I've seen worst case scenarios and I'm pretty adverse to risk, and I'd rather pay a few extra dollars twice a year than find out that I'm on the hook for a whole lot of money. What would I have done with those few extra dollars if I hadn't taken an umbrella policy? Well, maybe I would have had a good time or a nice dinner, or maybe I would have done nothing. So yes, I'm careful. I take it out. Again, don't want to scare you. Just want you to think about what your policy limits are and look at that declaration page. If it's been a while since you've looked at your insurance policy, you might do that. All right. So we tried the case, we got a verdict, we got damages. I showed you how that operates. Let's go back to our trial and see if we can get through the appeal stage in the time we have left. So if you're following along on the original outline, I am at page 8, appeal. So we tried the case, put on all the evidence, made wonderful closing arguments. We submitted the case to the jury. The jury came back with a verdict. Either side can now say to the court, Judge, and this is the trial court, Judge, there have been some errors made and we want you to correct them now. So we think you gave the wrong jury instructions, and we think we need a new trial. We think you admitted evidence that you should not have, and we want a new trial. Or we think you failed to admit evidence you should have admitted, and we want a new trial. The judge could do that. The judge could decide to set aside the jury verdict and give you a new trial. Or you might say to the judge, we think the damages are excessive or inadequate. Let's say in a case like this, the jury found, yes, there's liability. Yes, the other guy hit Ken. And yes, Ken was injured, and they awarded $10,000. We would say this doesn't make sense. We've told the jury about $35,000 worth of damages. They're saying, yes, the other guy is injured, or the other guy is liable, but this is inadequate compensation for Ken. It doesn't make sense. Please change the jury verdict. Or they awarded $1 million. I mean, I did such a wonderful closing argument. They awarded $1 million. And the other side would come in and say, Judge, that's just ridiculous. 99 out of 100 times this case was tried, no reasonable jury would award $1 million. And the judge can reduce damages, and that frequently happens. So there's corrections that can be made right there at the trial level. More often, the judge looks at all that and says, thank you very much, but no thanks. The verdict stands and the case is over. Now you could appeal to the appellate court. We're talking the state appellate court. And in Illinois, we have Illinois is divided up into 5 districts for the purposes of an appeal. And we're in the 5th district. So what would happen is either side that wants to appeal would give notice of an appeal. If it's the defendant here, the defendant would have to put up a bond, would have to show that if he loses on appeal, he is able to pay this. And interest is running all this time. So it's not like this verdict of $100,000 is sitting somewhere and inflation is eating away at it. Interest is going to run, and it's going to run at 6% interest. At the appeal level, all the appellate judges are going to see is the trial transcript, all the evidence that came in, and all the arguments and motions that led up to that. All those various things we talked about last time, motions to dismiss and motions for one thing or another, all that is going to be reviewed by the appellate court. The trial transcript, so it has to get prepared. The court reporter is there every day, but the court reporter is not transcribing that into written pages until 2 things happen. The court reporter knows it has to be done, and the court reporter gets paid to do it. So if you're going to go on appeal, you have to say to the court reporter, I need the transcript, here's the fee, please prepare it. That's going to take a little time. But the trial transcript, the jury instructions that were given, any tangible evidence, all that is going to go to the appellate court. Now, in our area, there are 7 justices on the 5th District Appellate Court. They sit in panels of 3. And hopefully those panels of 3 are randomly selected. Those 3 will review all the evidence. There will probably be oral argument. So the 5th District typically holds oral argument. It's in Mount Vernon. By the way, it's in Mount Vernon in an Abraham Lincoln era courthouse. If you ever have a chance to be there, you ought to try to tour it if they're open to tours. I don't know about COVID situation, but it's a beautiful old courthouse. There's a number of Lincoln artifacts in that building. So you would go up there, your attorney would go up there, the attorney for the other guy would go up there and would argue the case. And the judges sooner or later would come up with, the justices, we call them justices at the appellate level, would issue a ruling. It might be 3-0, it might be 2-1. That would probably end the case. Could you appeal to the Illinois Supreme Court? Well, you could try. There are a handful of cases that the Illinois Supreme Court must take. One of them was the death penalty cases. We don't have that anymore, so That's a non-issue. Beyond that, the cases are discretionary. They will take a case if there's a reason to. If the appellate court has had a chance to review everything the trial court did and says it's okay, in all probability, the Illinois Supreme Court is not going to take the case. If, however, there were some very new, interesting issue of law, the appellate court might take it, or the Supreme Court might take it. So in all probability, the appellate court in Illinois is the end of the case for you. Can you get it to the US Supreme Court? No. The only way you're going to get it to the US Supreme Court is if somehow there is an issue of federal law, and not in this case. So again, I'm going to share a screen here for a second. And just remind you of the structure of the courts. So we have the trial court in Illinois. The small claims court is part of the trial court. Then we go to the intermediate appellate court, which for us is the 5th District Court of Appeal in Mount Vernon. And then you could try to go to the state high court, which you're probably not going to get to. There's a parallel system in the federal system: trial court, appellate court, US Supreme Court. How can you get from a state court of Illinois to the US Supreme Court? Only if there's a federal issue, and there's not going to be in a case like this. If it were a criminal case and someone claimed that his right to an attorney all along here was not honored, that he might get to the US Supreme Court because there's a federal constitutional right to an attorney in a felony case. But unless we're going to show a federal issue, a constitutional issue, we're not going to the US Supreme Court, and probably you're not going to the Illinois Supreme Court. You're probably stopping right here with the Illinois Appellate Court. So again, I want to take a minute and talk about the appellate courts, because you're going to have an election in June. And I think the more we begin to understand this, the easier it is to elect judges. As hard as it is to elect judges, it's a little easier if we understand it. So we have one appellate court in Illinois, one Supreme Court in Illinois, that is the Illinois Supreme Court. It is for the entire state. For intermediate appeals, first level of appeals, we have appellate courts divided into 5 districts. The first district is in Chicago. The courthouse sits in the courthouse is in Chicago. It's for the Cook County. The second district, the courthouse is in Elgin, and it's basically the collar counties and a few other counties. The third district, courthouse is in Ottawa. It's basically northeast central, Rock Island, Peoria, that area. The fourth district is basically I-70 north across the state from Indiana to Missouri. Courthouse is in Springfield. And the fifth district, basically I-70 and south, courthouse is in Mount Vernon. Now, everything I just told you is going to be wrong in the matter of weeks. And that's because the districts have been redrawn. So after the census, which we do every 10 years, the legislature looks at the districts, whether it's the districts of state legislators, Congress districts, or Supreme Court districts, and reconfigures them. The fifth district is going to be greatly enlarged in size. And here's why. For a number of years, the area that is the fifth district, I-70 and south, has been losing population. There's a requirement that the district be more or less the same size and population. And in order to be the same size and population, we have to grow in geographic size to get more people. So I'm going to show you the maps. So on the left, in the more vibrant colors, the red is the fifth district as it exists right now. I-70 is basically right about here. So there's a couple counties just north of I-70 that are part of the fifth district, but basically the fifth district is I-70 and south. This is the fourth across the center of Illinois. North Central is blue, that's the third. This brown color is the second. Collier counties in northeast, or northwest rather, and green is the first. That's what's true right now. The legislature has redistricted. The new map is to your right, and it's the less vibrant colors. Don't ask me why, it's the best I could find. Right now, the Illinois Supreme Court has put a hold on this until I can work out a lot of logistical issues. But look at what's going to happen to the fifth. The fifth district, rather than be like this, is going to swing all the way up to Champaign. It's going to take in all this new territory. So all along the eastern edge of Illinois, all the way up to Champaign, through the center, not up just two, but not including Springfield, and then down to Metro East and down to the Ohio River. That is going to be the new fifth. The new fourth is going to be a large part of what it used to be, but then it's going to go all the way up to the Wisconsin border. And this is going to be the new fourth. The new third is going to be this carved out area along the eastern edge of Illinois up to Cook, but not including a little bit of the Collier counties and some of Central. The second is going to get reduced in size, and then Cook County. What you can see is that the population growth is in the second, and population loss is in the fifth. So you're going to have a new election. You're going to have an election in June for the primary, in November for the election. And it's very hard to know who the heck these people are. But in the past, you at least knew they were somewhere around Southern Illinois or Metro East. Now they could be all the way up to Champaign. So it's likely you're going to be looking at people you've never heard of. But who are they right now? Right now, in the 5th District, these are your appellate justices. They're John Barbaras, who's from Madison County, Mark Bowie, and I misspelled his name. There's no U. I apologize, Mark. I know him. He'll be mad at me for misspelling his name. So it's B-O-I-E from Union County. Judy Cates from St. Clair. James Moore from Williamson, our neighbor. Barry Vaughn, who I think is from Hamilton County. I'll tell you why I only think that in a minute. Thomas Welsh, who's from Madison County, and Milton Wharton, who's from St. Clair County. Barry Vaughn was just added to the court very recently to fill a seat. If you go to the 5th District website, each of these judges has a photo and something about himself, except Barry Vaughn. So either he doesn't want us to know who he is, or more likely he's just recently been appointed and hasn't yet filled it in. So I think he's from Hamilton. The others I know. I want to take a few minutes and tell you about Milt Wharton. Milt Wharton was not elected to the 5th District. He was appointed because there was a vacancy in the court. Let me give you a little story about Milt Wharton, because he's a judge that I admire a lot. And I think once in a while it's just good to hear some good news stories. Milt Wharton grew up in East St. Louis. He went to Lincoln High School, which doesn't exist anymore, but turned out a lot of good people in East St. Louis. He went to law school at DePaul, graduated in 74, and 2 years later became an associate judge in St. Clair County, which is in the 20th Judicial Circuit. Now, if I were in charge of the world, I would say that no one becomes a judge until they've been practicing law for 10 years. I think judges need some practical experience, and they need the wisdom of dealing with real people in real life. I've made up the figure 10. It's not in the law. That would be my law. Well, if that were true, Wharton would not have been an appointed judge in 76. So he's the exception to my rule, because I think he's pretty good. He was appointed to juvenile court. Now, most judges do not like juvenile court, and there's a couple of reasons why. First of all, the rules in juvenile court are different. So they have to learn rules that they probably did not learn in law school, and that vary from what they do for the most part. Secondly, it's very discouraging, because you're dealing with kids every day who got into trouble and you don't know what to do with them. Maybe they have dysfunctional families. You don't want to send them to prison, but they've done some bad things. What do you do? And if you do send them to juvenile incarceration, they typically come back worse than they were. What do you do with them? The other thing you handle in juvenile court is cases involving children who've been neglected or abused. And that can be extremely, extremely disturbing and wearing. So most judges really don't like juvenile court. Well, Wharton did. He really wanted to work with those kids. He wanted to make a difference. So for a long period of time, he was the presiding judge in St. Clair County, which is Belleville and East St. Louis, for juvenile court. He was elected a circuit judge in '88 and stayed there till 2012. So that is what, 24 years as a circuit judge. He retired and a vacancy occurred in the 5th district and it had to be filled until an election could be held. Illinois Supreme Court Carmeyer, a Republican, was then on the Illinois Supreme Court, and it was his job to fill this vacancy. And he went to Wharton, whom I can assure you is a Democrat, and appointed Wharton, who was retired by then, to fill in this vacancy. And then Dave Overstreet, who was on the appellate court in Mount Vernon, got elected to the Illinois Supreme Court. That created another vacancy on the 5th District Appellate Court. So Justice Overstreet then appointed Wharton to stay on for another 2 years. It is Wharton's seat. It's the seat Wharton's sitting in that will be up for election next year because Wharton is filling it during the vacancy. Wharton's been very active with the Illinois State Bar Association. The Illinois State Bar Association is a voluntary group. I don't belong. I used to, but I don't anymore. But it does a lot of good work, and some people go to these committees and do nothing. Wharton was the type of person who did a lot in the Illinois State Bar Association, worked on a lot of committees, and you see one of them on juvenile justice. He's been a lecturer for other judges. He's gotten awards, one by the ISBA, one by the Pope, one by the Boy Scouts of America, one by SIUE. He has been very active in the community. He founded a group called Racial Harmony back in the, I think it was around, at least by the year 2000. He tried to get people who were white and black together in St. Clair County, Metro East area, to sit down and talk with each other. And he founded a program which brings in adult volunteers to work with kids in the court system. That's a little bit of the story of Milt Wharton and why I think he is a really good guy. And I just wanted to share with you for no reason other than I think he's a good guy, and I wanted you to hear about a really good judge. Because remember when you asked me before, what about attorneys that drag their feet and don't move cases along? And I said to you, good judges never stop that, will stop that. Well, Milt Wharton was that kind of judge. He was the kind that would have stopped it. Let me pause and take questions because I've just covered a whole lot of stuff. Damages, insurance, appeals, 5th District, questions. The reason the Illinois Supreme Court stopped the movement toward the new map is logistical. There's at least one judge who will lose her job in one district and get transferred to another district because of the way these lines have drawn. But there's logistical issues for the attorneys. Where are you going to file lawsuits? Everything was just, the Supreme Court issued a rule that just said, keep things the way they were until we get it sorted out. And there are umpteen committees of the Illinois Supreme Court working right now to sort all this out. So by the time you and I have to go to the primary in June and vote, one can only hope that it has been straightened out. Who appoints appellate judges if they're not elected? The Supreme Court. So the Supreme Court, there are 7 judges on the Illinois Supreme Court. They are elected from the various districts. So the 5th District elects one of them. The 4th District elects one of them, the 3rd, 2nd, and the 1st District, which is Cook County, elects 3. So 3 from Cook, 1 from the collar counties, and 3 from the so-called downstate counties. So when a vacancy occurs, the Supreme Court fills it. The reality is the judge from that district is going to fill it, because in all probability, I don't think justices from Chicago know a whole lot about Southern Illinois judges. So in all probability, it's the justice from the 5th district. In this case, David Overstreet. Prior case would have been Lloyd Carmeyer, who would fill it. Touch on underinsured and underinsured. No, I'm not, because I don't understand it. I should understand it. I don't, so I'm not going to touch on it. Sorry, but I'm just plain passing on that one. Is the time to trial similar at the appellate level? One hopes not. One hopes that if you took this case to the appellate court, you would have a decision in a year. The 5th district is not backlogged. I would think you could get a decision within a year, but I can't tell you about the other districts farther north. All right. I'm supposed to tell you about mediation. And I think I will do a brief story and return to this on the 5th week. Last week, I told you, I referred a couple times to the fact that I had mediated a case involving this, that, or the other thing. And I made a mistake not telling you what mediation was, and somebody asked me, and I deferred it to this week. Mediation is this. It's a process for resolving disputes in which a third party, the mediator, sits literally in the middle between the parties and tries to help them resolve it. It involves 2 steps: listening to the parties and moving them forward toward a solution. Mediation looks forward, not back. The trial looks back. Did other guy run the red light and hit you, and were you injured? That's looking backward. Mediation looks forward. How are we going to resolve this and get this behind us so people can move on? It's used to settle cases. It's used to settle neighborhood disputes. So some years ago in Carbondale, the police were kept being called to this one home. A woman was running a daycare center, or at least babysitting her in her home, and so cars would come and go. And a neighbor called and complained that the traffic blocked their driveway. Now this is Carbondale. The traffic was not that extreme, but it was 2 or 3 cars, and the neighbor was mad and called the police. Through a long story, the police referred the matter to me when I was at Southern Illinois University School of Law running a mediation clinic. And somebody in my program mediated, sat down with the 2 neighbors. The dispute was not about traffic. The dispute was that some years ago, there had been some neighborhood dispute and somebody had called the police and they were still mad. And they were able to work through it, get an apology. Okay, yeah, we won't complain anymore about your cars. And they moved on. My students would go over to the courthouse during small claims court, and we would sit down with people that are suing each other for $10,000 or less. So, and here's a typical case. Somebody hires movers. The movers come and move the property, but they damage something. Wasn't a significant amount of money, but to the family it was. All right. Back and forth, they work out an amount of money that they're going to pay. So the mediator typically starts by saying, what brings you here? What are the concerns that you bring to this table? And then after some discussion of that, remember, we want to look forward, not backward. The next question will be, how do you want to get this resolved? How do you want to live together as neighbors in the future? How do you want to be respected as a mover in the community? What are you going to have to do to make this person happy so that she's not out complaining about your moving people? I mediated a lot of divorce cases. And in this area, if you have children and you're getting divorced, or even if you're not getting divorced, but you have children and you're in court over child support payments or paternity issues or who's going to do what, then if you're in front of the court is going to tell you to go mediate. And I used to do that. There is still a group of people, many of whom work pro se for people who can't afford a mediator, many of whom work for money for people who can afford a mediator to try to resolve it. This particular case could have been mediated probably after some discovery was done. It could have been mediated after trial to try to settle it there. It could have been mediated during the appeal process to try to resolve it short of appeal. Mediation is used internationally to resolve international disputes. It's used within a nation to resolve civil disputes. And when I say civil, I mean civil war, disputes among tribes or various groups in dispute within the country. It is used in cases, and this goes to a question about juries understanding facts. If you had a highly technical case, and construction's a good example. If there's a construction case, how many people are involved? The owner of the building, the general contractor, the subcontractors, electric, plumbing, heating, painting, the architect maybe there was an engineer. And one thing I can assure you, each of them is pointing the finger at the other one. Do you want a jury trying to listen to all these people and sort all this out? Or would you rather get all these people around a table and say, we've got a building, it's not working, there's a problem, how can we get it fixed? And so mediation is a great opportunity for construction disputes to get resolved. And in which case you probably want as your mediator, someone who knows something about construction. Mediation is used in intellectual property cases. So when General Mills and Kellogg's go to battle with each other over intellectual property disputes, it would be smart to have a lawyer who understands intellectual property sit down with them and try to work it out so they're not in court. So, short story about what mediation is. I've seen it used in large scale disputes where you actually have a team and it goes on for months. I'll tell you one last story and then we will adjourn for the day. In Georgia, I think Atlanta, there was going to be built a highway. It was going to go through a neighborhood that had historic homes. People that lived there did not want the highway. People that loved historic homes did not want the highway. Business people who were going to benefit from the highway wanted the highway. Environmentalists who thought there was going to be harm did not want the highway. Everybody was suing everybody. The matter had been tied up in the courts for years. Someone decided it would be a good idea to mediate. They brought in a team in that case of mediators. They had a room of, I'm forgetting the details because it's been a while since I've told this story, but I'm going to guess 20 people. And somebody finally said, you know, this is the first time we've all been in the same room at the same time. This is pretty good. In that case, the mediator would have spent time, and when I say time, it could have been days, with the environmentalists, days with the historic preservation people, days with the business people, days with the Georgia Department of Transportation. What do you want? What do you want? What do you want? What can you live with? What will work? Finally, they reached an agreement. So mediation can be used for simple disputes like the two neighbors that aren't getting along. It can be used for family disputes. It can be used, and one question I used to always ask people in family is, you know, when your child graduates from high school or gets married, do you both want to be there? Do you want it to be civil? Do you want your child worried the whole time that you're going to go to battle with each other? Or do you want your child comfortable because both of you are there taking pride in your son or daughter? Then what do you need to do now as divorced parents in the way you're going to finish raising this child so that 10 years from now, 18 years from now, You could be in the same room at the wedding or the high school graduation or whatever, and your child will be pleased to have both parents there. I never asked them to give anything up. I asked them, what can you do to get this behind you, to get this resolved so you can go on with your life? So that's mediation. Questions about mediation? All right, let me tell you what we're going to do next time.
Susan,
Yes.
I had a question in the typed up, and I couldn't get it into the into the list. In terms of mediation, I look back now many years to a trial that had to do with intellectual property. And my question was, is there ever a time when you could insist on having people technically capable of understanding the subject on your jury?
A couple things there. If it's a jury trial, no. There's no way I'm aware of where you could ask that the judge only seat as jurors people who understand the technical issues. No. However, you've got two alternatives. You probably have more than two, but two come to mind. One is mediation. And you probably would want as your mediator someone who has technical expertise in that field. But a mediator does not decide. What's very important to remember is the mediator does not decide. Who decides? The parties decide. The mediator helps them. I used to call it like an orchestra leader. I direct the orchestra, but you're the orchestra. You make the decision. So a good mediator who has technical expertise would be able to bring out the weaknesses in both sides' case, get each side to recognize the strengths in the other guy's case and try to help them move forward. But that would be mediation. There would be no decision by the mediator. It would be up to the parties. Arbitration, however, might be an area where you could, let me rephrase that. It is an area where you could have technical expertise as your judge or your arbitrator. Tune in week 5. We're going to talk about arbitration week 5. So
Okay.
Barbara, thank you for the question, but come back week 5. See, that's a
Okay.
way to get you to come back.
Well, so long as I got the instructions to zoom in, I'm here, but I
All
didn't
right,
get them
very
last
good.
week.
Oh, I'm sorry about that. I control a lot of things here. I don't control how this technology works. So we're all at the beck and call of that. All right. So next week, I'm going to return to that 11-page outline I gave you for week 1. And we're going to talk more about common law. We're going to talk more about torts. And we're going to talk about some areas where you don't have a duty. And you're going to be very surprised to find out that you don't have a duty to do some things that you probably think you have a duty to do. At least the law doesn't tell you that you have a duty to do them. And after that, you're going to have to bear with me and as I decide what we're going to do next week. But those two things I know we'll do next week. So that 11-page outline that I gave you for week 1, make sure you have that next time.
Could I be sent that, please?
Barbara, only if you're really, really nice to me.
Pretty please?
Sure. Anybody else needs it? All right. Thank you all. We will see you next week.
Thanks, Suzanne.